If you're pulled over for a DUI, impaired driving investigation in British Columbia, can the police search your car? Now, this is a complex one, and many police officers actually get this wrong. In British Columbia, we have what's called the IRP scheme. It is a legal scheme. Scheme isn't a bad word, okay? It just speaks of the structure of the system that's been created by legislation and regulation and been developed. And the IRP scheme allows the police to compel you to provide a sample into an approved screening device, that is relying on the federal criminal code authorization to make a demand to blow into a roadside breath tester. Then, if the police officer makes the determination after that rather than arrest you and taking you back to the detachment to provide a sample for a criminal code investigation, they may make a determination to proceed, as they say, by way of IRP, to issue a driving prohibition, 90-day driving prohibition, and a vehicle impound just there administratively at the roadside. Now, the moment the police officer makes that decision, the criminal code investigation ends, and the police officer is supposed to read you notification about your right to a second test on a different device, and that the lower of the two readings will prevail. So the criminal code investigation ends at that point. Now, that is important context, because typically when you're pulled over and you provide a sample into a roadside breath tester, an approved screening device, and you provide a fail, the police officer at that point has reasonable and probable grounds to conclude that you've committed the offense of operating or having operated a motor vehicle with a blood alcohol concentration over 80 milligrams in 100 milliliters after operating the motor vehicle within that time period that's specified in law. So the police officer has at that point the grounds to detain the person, take them back to a detachment for an investigation, still holding them and detaining them. But in BC, most of the time, better than 90% of the time, people provide a sample, and the police officer then says to themselves, I'm not going to conduct a criminal code investigation, even though I told you that I was, or that I'm already told you about your right to talk to a lawyer. I'm not going to do that. I'm going to go by way of IRP. Now, in a criminal code investigation, of course, the police officer does have the authorization to search the surrounding areas for anything that is offense-related or anything that is a potential threat on your person. So they can do a pat-down search of an individual before they handcuff them or when they handcuff them and place them in a police cruiser, detaining them. So you blow a fail. Typically, the police officer at that point is going to say, I'm arresting you now, or I'm detaining you now for an impaired driving investigation, and then explain your right to counsel and handcuff you at the same time, or before, just beforehand. And they've got a right to search then, and they could go search your car right then. But what happens when the police officer decides to go by way of IRP? Well, the moment the police officers decided to go by way of IRP, there's no longer any criminal code right to detain the person. The criminal code investigation is over. And so any search that is conducted of the vehicle after the police officers made the decision to proceed by way of IRP is no longer authorized in law. The search beforehand, when a police officer legitimately is thinking, I'm conducting a criminal code investigation, is authorized by law. So the police officer can go do a cursory search of your vehicle, not, pulling things apart, but, maybe you look in the glove box, look under the seats, looking basically for alcohol or something else that would be offense related, okay? And they might stumble upon something else. If you've got pepper spray under your seat, you're in trouble. But the moment they make that decision to go by way of IRP, that authorization to search that vehicle no longer exists. There's no criminal code detention anymore. So it's no longer a criminal code process that would allow you to search that vehicle. And there's nothing in the Motor Vehicle Act that facilitates or permits a search. So any search after that decision to go by way of IRP is a Section 8 violation, the right to be free from unreasonable search and seizure. A reasonable search and seizure is one that's authorized by law. Every search is a warrantless search unless it's a warranted search, right? And warranted searches are on the face of it, prima facie unreasonable unless authorized by law. And the only authorization that arises in law is a result of the fact there's a criminal code detention and investigation. And the moment that criminal code detention and investigation ends, so does that right to search. So very often we will see police officers searching vehicles after they've made the decision to go by way of IRP, and that's not authorized in law. One exception, okay, so this is why it's complex. A police officer can do a quick search of a vehicle before it's towed. So the vehicle is going to be towed and taken into impound, And after basically when the tow truck's already there and the person's collected their stuff from it, or had that opportunity to collect their things from it, the police officer can go over there and do a quick look to see whether or not there's anything in there that they should be worried about being stolen, basically, or worried that they're going to be somebody's going to be coming back and saying was taken from the vehicle. So that's the rare exception. So complex for police officers, I see it conducted incorrectly all the time in IRP disclosure, where police officers go search vehicles after they've made the decision to go by way of IRP. There may be some value in it for the individual, because if the police officer finds something that calls into question the reliability of the tests, that can be useful evidence for the hearing. Sometimes it's valuable for the police officer because they will find something, and of course, then if they were to decide to charge somebody on it, like that bear spray, you'd end up with a situation where chances are that person would have a pretty damn good argument to argue that it was an unlawful search. But it's hard to wrap your mind around those rules. So I would say rule number one, you provide a fail reading into a police breathalyzer. At that point, the police have to give you your charter rights, and they could go search your vehicle for something offense related. If, however, they've made the decision to proceed by way of IRP, even if they've decided to read you your charter rights, but really they were going to go by way of IRP, then that authorization no longer exists, and they can't come searching your vehicle until the end when they're towing your vehicle, at which point they can walk over and say, okay, look around there. And basically they should be doing no more than just looking around. But if at that point they see something, pepper spray and a baseball bat and a knife, then you might have some other problems. But police should keep in mind that there are still limits on their power to look around in somebody's vehicle in an IRP case. And the moment the decision is made by way of IRP, it's no longer a search that is authorized by the criminal code, because the criminal code detention is done. Try and wrap your mind around that one. This is one of the reasons why I suppose AI will never be replacing lawyers when it comes to arguing these things, because there's no way AI will ever get that one right.